Hello, welcome back to my channel. My name is Carly Stevens. This is Carly Stevens Books for all things writing, publishing, and indie author life. And I have the distinct privilege of being back with Leslie Budewitz today. Hey, Leslie.
Hey, thank you, Carly. It's great to be with you again.
Thanks. Yeah. A while ago, we talked, I asked you questions about creating amazing characters. So if you have not seen that interview, go back and check it out. There's a lot of amazing insight. But we have a very different topic today. It's what readers or what writers get wrong about lawyers. So let me tell you a little bit about Leslie, and then we'll dive in. So Leslie Budowitz writes the Spice Shop mystery set in Seattle's Pike Place Market and Food Lovers Village mystery set in Northwest Montana. She also writes standalone suspense as Alicia Beckman. In 2011, she won the Best Nonfiction for her guide for writers, books, crooks, and counselors, How to Write Accurately About Criminal Law and Courtroom Procedure. A three-time Agatha Award winner, a past president of Sisters in Crime, and board member, I can't speak today, of Mystery Writers of America. Leslie lives in Northwest Montana. So let's talk about what people get wrong about lawyers. It's such a popular thing to write about in novels and to see in TV shows, but um, obviously people don't always get things right. So before we kind of get into the nitty-gritty, tell us a little bit about your background and what makes you a good source, a trusted source for giving us this information about the inner workings of lawyers.
I realized that I did not grab my copy of books, Crooks, and Counselors to flash as my resume. It's across the room from me right now, and I can't easily get to it. I am a lawyer. I graduated from Notre Dame Law School in 1984, which is just a shockingly long time ago, at least to me. And for a year, I clerked for the Washington State Court of Appeals. And clerking is where young lawyers work with judges. We research their cases for them, help them form their opinion, the written opinions,
Hmm.
and just kind of a finishing school for lawyers. We dealt with a wide variety of cases, both civil and criminal, and that gave me an introduction to the wide range of practice. After that, I started practicing in Seattle and then came back to Montana, about 30 years ago. And I am still a practicing lawyer, although these days mostly I write books. But I do still practice. I'm picked up this stumbling from you, or maybe you got it from me. Who knows? So most of my practice has been civil litigation, personal injury, business litigation, a lot of employment law. But I have done an unhealthy dose of criminal law as well. And so I know a fair amount about a wide range of areas of the law. These days, I work as local counsel for out-of-state law firms who need a lawyer in Montana to help them guide their way through the rules, and work as an appellate mediator for our state Supreme Court. And then, as I said, or as you said, I write all these wonderful books. At least I think they're wonderful.
I knew it going into this that you obviously had a lot of law experience, that you had been a practicing lawyer. I didn't realize that you were still so active in that sphere. So it's incredibly fresh in your mind and you're using these concepts every day. So for people who might not know, lawyer is quite a broad term. What kinds of professions can that actually encompass specifically?
Yeah, so it's tempting to say that there are two kinds of lawyers, good ones and bad ones. But it's really a lot more involved than that. There are two kinds of lawyers, basically. People working as lawyers can either be in the public sector or in the private sector. Of course, there are plenty of people who are trained as lawyers who may or may not have a lot of experience in practice, who work in adjacent areas or areas where their education and experience is useful. For example, some of my law school classmates are just some of the non-practicing Boy, I'm really stumbling today. Some of the jobs that law school graduates have that are not active practice of law, but still use their experience and training might be my classmate who is head of a major bank, one who's a diplomat, one who runs a land conservation organization, and all kinds of areas like that where having a legal education and some experience is useful, but it's not the active practice of law. So first, let's think about the public sector. The most common, the ones that we're going to know the most about, are the prosecutors and the public defenders. Some areas of the country, particularly those that are smaller populations, will occasionally have systems where the defense lawyers also are in private practice and they are contracted for a particular case rather than working as a public defender. But for the most part, those are the two main areas of public sector practice that we encounter in television, in movies, and in books. But another major area of private sector practice is the government lawyer who works for an entity, for example, who works for the state or a county or the federal government. And those people can be litigators who, say, represent the US Department of Justice in a fair housing violation case. Or they might be on the regulatory and advisory side. For example, here in Montana, the Board of Medical Examiners is under the purview of the Department of Labor. Well, the Department of Labor has a group of lawyers within the agency who advise the various agencies, such as the Board of Medical Examiners or the Human Rights Bureau or the other agencies under their purview. A lot of government lawyers work in that context. Then on the private side, we can split it into two again. And there are lawyers who work for organizations such as corporations or nonprofits, and lawyers who work in law firms. And the lawyers who work in law firms are the ones we think of the most often. And that's what most of my practice has been. And we can do almost anything you can imagine. We could be regulatory, we can be family law practitioners, we can work in nonprofit arena, but as a law firm, which is kind of an unusual sector, but it's an increasingly common one. Or the more typical scenario where we're the advisors, counselors, and litigators for personal injury litigation, business litigation. As I mentioned earlier, I did a lot of employment law. So I dealt with employers who had wrongful discharge lawsuits brought against them or discrimination claims. I wrote their handbooks and tried to help them avoid problems in the future. So those are just a few of the areas that lawyers can work in, even though some of them we see in fiction a lot more than others. Some are just not, it's not always that interesting, but even some of the areas you might think are not that interesting, a good writer can make interesting. And I'm thinking of some of John Grisham's books, particularly if you think of The Pelican Brief, which was also a great movie, that deals with environmental law and regulation. And it becomes interesting in the hands of a good storyteller.
I knew there were many subsections to that huge umbrella, but as you kept listing more, I went, "Oh, right. Oh, yeah. Oh, oh, right. There are those people who are just there primarily to advise and, adjust and, much more than just the very obvious prosecutors, defense attorneys, personal injury lawyers that we see those
Mhm, mhm.
those banners along the
You can
highway."
think of the work as falling into the problem solvers and the problem advisors. As some of our work is to help people avoid problems, and then some of it is to deal with problems when they in fact arise.
So let's get into kind of the big question then. Of the books that you've read and the shows and movies that you've watched, what are some of the most common misconceptions or wrongful portrayals of lawyers and what they do that
Yeah. Yeah.
aggravate you?
I give a presentation for lawyers on common mistakes, and I've stopped putting a number on it. It used to be 10, and then it was 12, and one time it was 15. And, I can come up with as many mistakes as the time period I'm allowed will fit into the time period. But I will tell you the two biggest ones. The biggest one is mistaken terminology. For example, on Law and Order, and I love the show, every lawyer is a DA, a district attorney. But that's not the case in the real world. And I've read books, manuscripts, and actually published books set in areas where I know that that's not the terminology, but that's the terminology that the author has mistakenly used, because in many cases we're TV educated. The district attorney in New York, which is where Law and Order is set, is a lawyer representing the state, but the state is divided into judicial districts, and that's where that terminology comes from. In the federal system, we have U.S. attorneys, and then we have assistant U.S. attorneys, and they represent various districts too, but they're not called district attorneys. What's more common, and most litigation, both criminal and civil, is in the state court systems. And so you've got to know what your state's courts are called and what the prosecutors are called. Are they a district attorney? Are they a county attorney, a county prosecutor? In Virginia, they might be the attorney for the Commonwealth. They might be the people's attorney. And so you need to figure out those terms. The same with the court. The main court, what we would call the court of general jurisdiction, can be the district court, as it is in Washington State, where I practiced for a number of years. No, I'm sorry, it's the Superior Court. See, I'm even confusing myself. In Washington State, it's the Superior Court. In Montana, it's the district court. And it might be the circuit court somewhere else. Now, it's not going to be that hard for you to figure this out. The first thing I would suggest you do is read the newspapers for your story state and look at the Cops and Crimes page, Cops and Courts, Cops and Crimes, whatever it might be called. Read those stories. But also there's going to be a website for your story state that lays out what these systems are called. And there is actually a national organization called the National Association of State Courts that has all 50 states plus the territories listed, and links for breakdowns with diagrams that will show you what the various courts are called. And then you can also figure out what the prosecutorial and defense system there is. So that's the first common mistake I want to mention is terminology. The second is Miranda warnings. This is incredibly common in fiction, where as soon as an arrest is made, the police officer will give a Miranda warning. I've even read books where the author says that the case was dismissed because there was no Miranda warning given. Let's think about what a Miranda warning is. And I did not bring over to where I'm sitting my little copy of the card. But we all know the language. It is the advice that you have the right to be represented by counsel. And if you choose to give up that right, anything you say can or will be used against you. That was established in the early 1960s in a case called Miranda versus Arizona. And funny but not funny story about Ernesto Miranda, the criminal defendant in that case. He actually, when he was in prison, so what happened was Miranda was arrested and he was not advised of his right to counsel, and he made some statements that incriminated him. And then ultimately the Supreme Court held that he needed to have been warned. He was retried without those statements, and he was still convicted. And he was kind of a career criminal anyway. But when he was in prison, he actually made a fair amount of money selling signed Miranda cards that he would sign himself. Anyway, so when is a warning required? A warning is required when a person is in custodial interrogation. And those are the two crucial elements. We have to have a person who is in custody, and we have to have interrogation. So if your fictional suspect has been arrested and they're sitting in jail, or they're sitting in the back of a police car and there's no door handles and they can't get out, whether they're in cuffs or not, they're in custody. There's going to be some other situations where whether they're in custody is questionable. So there's room to work with the facts. But then we also have to have interrogation. If a police officer is simply having a conversation and not asking questions, then that's not interrogation. But if they are pointedly asking questions, then of course that will be interrogation. One example that I like to play with, because it's rather horrifying, is a real one, where a man was sitting in the back of a police car, can't get out, clearly in custody, car's in motion. The two police officers are sitting in the front, and they're having a conversation about this absolutely horrific scene that they've just been to, where a child's body has been found, and it's bloodied and damaged, and the child is dead. And they're talking about this, and one police officer says to the other, "What kind of animal would do something like that? What kind of son of a bitch would do that?" And our suspect in the back says, "You leave my mother out of this." Well, it wasn't interrogation. It was just a conversation, right? Actually, what he said was, "You leave my mother out of this. She had nothing to do with what I did to that girl." So we've got a confession. It was custodial, but it was not in response to interrogation. And so it would be admissible in court. There are all kinds of variations, situations you can come up with, and ways you can use the facts to vary the scenario, and to fit what you as the author want to have happen. But those are the basics. A warning is not required unless we've got both custody and interrogation. And if a warning was required and isn't given, then statements made in response to that interrogation are not going to be admissible in court. It may or may not mean that the case has to be tossed, that there isn't enough evidence. It just depends what other evidence there might be. But you can do a lot with that scenario. What you shouldn't do is have your police officer warn a suspect as soon as they're taken into custody, or as soon as they're encountered, because nothing shuts a person up more than a warning, especially someone who has experience of the system.
Ooh, so just for the sake of clarity and because I'm curious, if there is a witness questioning, I guess it would still be interrogation, somebody who was not otherwise a person of interest or a suspect, would they just as a matter of course get their Miranda rights read at the beginning of, say, a taped interview?
No, no, if you are not a suspect and you are just being questioned as a witness, no, then you don't have a right to be warned.
Okay. I would have thought not, but I was imagining a scenario where somebody like that then incriminated themselves somehow, and then would you have to switch over and then
Yeah, now that's an interesting scenario. That can certainly happen, where during the course of questioning someone says something that turns them into a suspect. At that point, a warning would have to be given.
okay.
Now, another situation is where a person agrees to be questioned and then decides to revoke that consent and says, "Oh, wait, you know what? I better have that lawyer." Or says, I want to have a lawyer, and then before the lawyer gets there, decides to start talking. All those scenarios happen.
Hmm. And you get into some of that in your books, Crooks and Counselors.
Mhm,
Uh,
mhm.
okay, fantastic. Yeah, if you write mysteries or thrillers or legal, procedural, anything, you have to check out this book. I was enthralled, and it's not even the genre that I write. It's set up in like a question answer kind of format, and so if additional scenarios are coming to your mind, like they're coming to mine because of all the true crime I consume, then look there, I guess, for more question or more
Yeah.
answers.
It's
So
160 questions and answers, and it's broken down to explain the structure of the court system, and then what crimes are, criminal procedure, what evidence is. Oh, that brings us to another one. Can I mention one other
please,
common mistake?
please.
And that is the distinction between direct and circumstantial evidence. And very often in TV shows in particular, I have seen uh, the argument made, well, we can't prosecute because we only have circumstantial evidence. Circumstantial evidence is still evidence, and it may be enough or not. So what is evidence? Evidence is anything that has a reasonable relationship, a reasonable tendency to prove a fact that's at issue in the case. If it could prove it, then prove a fact that's at issue in the case, then it's going to be evidence. That can be testimony, it can be DNA sampling, it can be a gun, physical evidence like that. It could be documentary evidence, which is very common in civil litigation. And so direct evidence is eyewitness evidence of a fact relevant to the case. Circumstantial evidence is evidence of other facts that lead to presumptions of facts that are relevant for the case. So here's a classic example. You tell your children not to eat the brownies before dinner. You leave the room, you come back in, you see that 2 brownies are missing. You look at your kids, you see that your son has chocolate marks on the side of his face and crumbs going down the front of his face. You didn't see your child take that brownie. You didn't see your child eat it, but you have circumstantial evidence that he in fact did eat it. You see your daughter holding a brownie in her mouth. That's direct evidence. So, direct evidence is you saw the kid take the brownie and eat it. Circumstantial evidence is you saw the smears of chocolate and the crumbs. They're both evidence. They're both admissible. Frequently, with circumstantial evidence, we need more of it, but not always.
That's just what
In
I was
this case,
thinking.
in the brownie case, the case of the purloined brownie, you don't need a lot to establish that particular fact. So circumstantial evidence is enough to convict in a criminal case.
That's good for people to realize. You don't have to have DNA, you don't have to have fingerprints. You can have this burden of proof from all these other areas that all point to the reasonable inference that this is what happened.
Yes, yes. I'm glad you mentioned that you don't have to have DNA. There is an effect, a phenomenon in criminal law referred to as the CSI effect. And that is that because jurors have seen so many TV shows where forensic evidence, whether it's fingerprints or DNA or something else, are relevant or are part of the case, jurors tend to look for them, and they say, wait, this can't be established beyond a reasonable suspicion, or beyond a reasonable doubt, sorry, because there was no DNA evidence. And so prosecutors these days, sorry, there's my cat yelling outside the door. It's getting close to feeding time, and he's very old, which means he's deaf and he's loud. Prosecutors actually say in their opening statements, there will or there won't be this kind of evidence to make sure that the jurors aren't looking for it, and that they realize they don't always need DNA or fingerprints or something like that, some sort of forensic evidence in a case.
It's a shame. That would make uh, it an already difficult task to prove something beyond a reasonable doubt
Yeah.
even more challenging for prosecutors and the people in that sphere. So speaking of attorneys, both prosecutors and defense attorneys, what are some of the less understood rules about the relationships between attorneys and clients? Like I've always wondered, could defense attorneys drop a client if they find out that in fact this client did commit a multiple homicide, like, and their conscience just can't take it, if that ever happens. Would
Yeah.
that be possible to do?
Generally, no.
Generally, no.
As lawyers, our duty is to the system. And let's step back for a moment and remember what a prosecution is. A prosecution is brought by the state as a representative of the people. A crime is a crime because it is something that violates the order of society. It is not just that it injures a particular person. And that's why criminal prosecution is not brought by a particular individual. It's the United States versus Enron. It's the state of Montana versus Mr. Ingram, and so on. Rather than the individual victim. And so what that means is that we have a relationship between the parties that's governed by this relationship of who the client is. So, for example, the prosecutor's client really is the people, and the defense lawyer's client is the individual defendant. But our relationships are governed as lawyers by a complex set of rules called the rules of professional conduct, or the rules of professional responsibility, or something like that. They're state by state, and so names vary. And they govern when we can withdraw from a case or not.
Mm,
You will hear defense lawyers say that they don't ask their client, are you guilty? Did you do this? Because they don't really want to know necessarily. Now, that might sound to an outsider like closing their eyes to the truth. But the defense lawyer's obligation is to make sure that the state proves its case beyond a reasonable doubt.
hmm,
And so what the client might tell you is important, but you don't necessarily want to know, did you do it? The question is, did the state prove its case? Now, your scenario is an interesting one, and that is, say that the defense lawyer comes up, develops evidence or sees the evidence in the case and is pretty sure that the client is guilty. Can they withdraw? No, because their duty is to continue representing the defendant through that process and insist that the state prove its burden,
hmm,
prove every element of the crime by beyond a reasonable doubt. And what I mean by element of the crime is crimes are defined by statute, whether it's state or federal. And the statute will define what needs to be proven. So, for
hmm,
example, in an arson case, there has to be evidence that a fire was deliberately set or was set with reckless disregard, and the building has to be one in which people live or work or could be found.
hmm,
And so, there are these elements, and then there may be degrees of damage, and there may be degrees of the crime too, and that's all set out by statute, and those are what we call the elements of the case. A defense lawyer, a criminal defense lawyer, can usually withdraw only for very specific reasons. If, for example, he's not being uh, does not have a cooperative client, thinks the client is not telling him the truth, or if the client says or does something that gives the lawyer reasonable grounds to believe that someone else is in danger, then the lawyer has to go to the court and reveal this and would probably then have to withdraw. It's an unusual situation, but it does arise.
Oh, that's interesting. So it is possible, it's just not at your own personal random discretion. It has to be a very particular and pressing circumstance
Mhm,
for a
mhm.
defense lawyer to step down.
Now, even in civil litigation, not in a criminal case, but in a civil lawsuit, our ability to withdraw is limited. We
Hmm,
can't withdraw just because we are sick of the case or sick of the client. We can withdraw because we haven't been paid. We can withdraw if we think that the client is not cooperating, or some other very specific circumstances that are set out either in the rules of professional conduct or in statutes. And it doesn't happen very often, and you have to get the court's permission, basically, unless it's really early in the case. But typically, you have to get permission. I have had to do that a couple of times, and
hmm.
it's unpleasant.
I would imagine it would have to be. I'm trying not to get in the weeds here. All these different circumstances are coming to mind, like just the sheer length of the O.J. Simpson trial, and
Mm.
what if you were on the verge of retirement and you were only planning to go for another month or so, and yet you're just locked into this endless, parade of hmm,
Well, in that situation, if you needed to retire for personal reasons or for health reasons or something like that, you could turn the case over to another lawyer.
hmm,
But you can't just abandon your client.
okay, that makes
That's
more.
actually grounds for disbarment, to
Oh,
abandon your client.
that makes sense. That makes sense. You want to know that lawyers are capable and knowledgeable and follow those rules, on your behalf. Hopefully on your behalf. Okay, I have a few specific questions, things that I
Okay.
see in shows, things that come up in books that I want to see, is this how it happens? Does this happen at all? First, it's really common to see a scene where there's a will being read and all of the people who might be recipients of something gather around, and the lawyer stands up and begins reading this will, who gets what, and it's all dramatic. Does any version of that happen in real life, or is that just dramatizing something that normally happens very quietly?
Well, I'll tell you that my favorite will reading scene is clearly the Chewy dog food commercial, or cat food too, where the cat, Mr. Marble, is lounging in the recliner listening to the will being read while the adult children are horrified at being cut out. Um, Short answer is no. Will readings are really not conducted. I have heard of a few instances, but it would be rare and unusual. Rare and unusual, both those things.
Nearly unique, but not quite. If somebody maybe requested a will reading, then they could set one up, or
Yeah,
I mean, if they're
yeah.
rare, then they
Um,
happen sometimes.
it does happen sometimes, but I personally have never been involved in one. But I suppose that a lawyer might choose to do that, or a decedent might have requested that for some particular reason. Usually, what happens is the heirs are notified that they are actual or potential heirs, and they're given a copy of the will. You get it in the mail.
Oh, it's much less cinematic than sitting around and being shocked when all you get
Yeah,
is a
yeah.
package of spoons and this person gets a house. Okay, another one. This happens all the time. It works great for dramatic effect, but is it something that actually happens? Can lawyers surprise each other with evidence at a trial, or does every single thing need to be approved beforehand? I know things can get approved kind of during the process of a longer trial, but is it possible to say, "We've found the murder weapon, yesterday," or can you do things like that and still have it be legitimate?
No, no, in the real world, we have a process called discovery. And it means that each side shares its evidence with the other. In a civil suit, say a car accident or a pollution claim, the litigation rules require discovery be mutual. And so each side provides everything it has to the other side. There can be odd little glitches, blips. I remember many years ago handling a personal injury lawsuit where, for some crazy reason, the plaintiff's lawyer did not ask for my school bus company's report on an accident. And nothing that they asked for, I couldn't find a way to say that their requests covered this report. And they wanted that report because the bus driver had been at fault, and the employer had investigated and concluded that she was at fault. But under no version of their discovery request did they ask for that. And I felt really kind of nervous. Am I withholding something that I should produce? But the lawyers I worked with, we all looked at it. We all agreed that they just forgot to ask for the documentation of any internal investigations. Now, it's all right because we did settle the case appropriately. We recognized that the driver was at fault, even without them having had the benefit of that report, and the injured person got properly compensated. That's a civil litigation example. In criminal law, it's a little bit different. The state has to produce all the evidence that it has, but the defense doesn't necessarily have to produce everything it has. And the reason for that goes back to this burden of proof that we briefly talked about.
Mm.
The state has the obligation to prove the elements of the crime beyond a reasonable doubt. The defense doesn't have to prove anything. They may dive in and try to prove an alibi, for example, or a case of mistaken identity or something like that, but they don't have to prove anything. And so the defense obligation to produce evidence is very limited. There are going to be some things they're going to have to produce, for example, the list of all their witnesses and that sort of thing. I want to mention a term that some of your viewers may have heard recently. It's called Brady material, and it is named for a United States Supreme Court case, probably from the 60s, called Brady versus Maryland. And that case held that if the state, the prosecuting entity, the federal government, the state, the tribe, whatever it might be, has evidence that exonerates the defendant, or I'm missing the exact word, right? Exculpates,
Oh, yeah,
exculpatory
exculpatory
evidence,
evidence.
then
Yeah.
they have to produce it. And there was a recent case in the news, and I can't remember the name or the details, that involved exactly that sort of failure. It is still occasionally a problem. So the state absolutely has to provide any evidence that could reasonably be interpreted as exculpating the defendant.
So if the defense were to hire their own private investigators, which I know isn't, is something that happens, and
Mhm.
they were to dig up an explosive document that the state had not found, then they could bring that into court and not provide it to the prosecution?
No, they would have to provide it
They would.
because you do have to provide your list of witnesses and your documents in
Okay.
advance. There are very few surprises left in litigation. I
I
list in terms of the
suspected that that
evidence.
was the case, but I kind of wanted there to be some situation, some loophole where there could just be this grand moment.
There is, a term, am I gonna be able to come up with it? Rebuttal evidence. So the state puts on its evidence and the defense puts on its evidence, and say something comes out that wasn't expected, then
Mm,
the state in rebuttal might be able to bring in new documentation or a new witness who had not previously been disclosed. But
hmm.
that's pretty rare because usually we can anticipate what the other side's arguments are going to be.
Right, that makes sense. You would have to anticipate what the opposing arguments would be so you could provide, do some additional investigation and
Exactly.
all of that to make sure that that wasn't going to hold any water. Yeah, this is fascinating. I could talk about this all day, but I probably should wrap things up. Um, if you have any other questions about this kind of information, then definitely check out Leslie's book, books, Crooks, and Counselors: How to Write Accurately About Criminal Law and Courtroom Procedure. It is not only incredibly informative, but also it's really entertaining. I was going through it and I just kept thinking, "Oh my gosh, what about this circumstance?" And then an answer would be on the very next page. So something that I
I'm
noticed
glad you
in
enjoyed it. Can I also mention
Yeah,
that on my
please.
blog, on my website, lesliebudowitz.com, there's a blog, and occasionally I will deal with some legal issue uh, that I think is of interest to writers. I haven't written about them much recently, but the archive is still on the website, and there are stupid criminal tricks and interesting developments in the law or cases that have been in the public eye that I want to talk about for writers. And so check out the blog as well.
I'll definitely put that link down below. So, yes,
Thank
check
you.
out the archive. And is there a way that people can contact you? Are you open to being contacted
Sure,
about this kind
sure.
of information? Just through your website again?
Yes.
Okay. All right.
Leslie at lesliebudowitz.com.
Perfect. Perfect. So to cap things off, what is your favorite lawyer joke? I know you have a bunch. I know you've heard the good, the bad, and the ugly. What's your favorite?
The favorite one, of course, has got to be, did you hear about the lawyer who gave up her job to write a novel because she wanted to make a lot of money?
That's so dark. I love
That's
it.
so
Well,
true.
it's it has been just a joy reconnecting with you, and I appreciate your insights so much. I know people who are writing in these related genres are just going to be eating this up. So, yeah, thank you, thank you. Is there anything else you want to pitch before we close things out?
I'll just say thank you again for the invitation. It's always a delight to talk about this sort of thing, and always a delight to talk with someone who is so interested as you are. So I appreciate the opportunity.
Oh, well, it was my pleasure. All right, well, check out those links down below. Definitely check out Leslie's book, and her fiction as well. If that's your cup of tea, look at those cozy mysteries and those thrillers. Uh, and yeah, I will see you next week. Bye.
Bye.